Okay, good morning, ladies and gentlemen. We're here in the Franklin Circuit Court for a pretrial conference and a status conference, I guess, in the case of Council for Better Education versus Johnson. It's number 21 CI 461. And I scheduled this just so that we could address some of the procedural issues and scheduling matters that we need to talk about before to see how we can get this case briefed and argued and submitted in the most efficient fashion. So we've got a couple of matters that we need to talk about. Obviously, one of the things, and I don't see anybody from the Attorney General's office here. Do we have anybody from the Attorney?
Yes, Your Honor. Christopher Thacker, Assistant Deputy Attorney General, and Heather Becker is also on the call for the Attorney General.
Okay, great. All right. Thank you, Mr.
I'm new at the office, Your Honor. So
that's fine. Glad to have you with us and glad to have you on the call here today. So. And of course, Ms. Becker is no stranger to the Franklin Circuit Court, so I have her as well. So, okay, well, let's start. I guess a couple of things, so just off the bat, and I guess since I've got Mr. Thacker on the, well, I'll tell you, before we do that, why don't we just, let's go around the table here, or the virtual table, and let's let everyone enter their appearances so I, have a clear idea of who we've got on the call and who you represent. So why don't we start with the plaintiffs, and I'll recognize Ms. Snell, and then we'll go around the tables.
Good morning, Judge. I guess I'm unmuted, I hope. I represent,
yes,
along with Sean Williamson, I see is on with us, and Sean and I represent the Council for Better Education, the Warren County School District, and the Franklin Independent School District.
Okay. All right.
Yep. Good morning, Judge. Jeff Walther. Here in the office with me is John Wood. We represent the individual plaintiffs. And if I could introduce our co-counsel, Eric Harrington and Kristen Holler from the Office of General Counsel at the National Education Association.
Good morning, Your Honor.
Okay.
Eric Harrington, representing Michelle Grime-Jones, Catherine Walker-Payne, and Chris Rashid.
Okay.
Kristen Holler, representing Michelle Grimes-Jones, Catherine Walker-Payne, and Chris Rashid.
Okay.
Good
All
morning.
right. Is that all of our plaintiffs then? And then I see Mr. Thomas, I guess, on behalf of the Secretary Johnson.
that's correct, Your Honor. Brian Thomas. Also on the phone is Bethany Rice and Jennifer Stossberg, representing Secretary Johnson and Commissioner Miller.
Okay. Okay, and we have got, I think, some of the movements for intervention. So who do we have for the interveners? Mr. Metzger?
Yes, Your Honor. Thank you. Lee Metzger, local counsel for the proposed intervening defendants, McNeary and Deaton. I'm joined by my co-counsel from the Institute for Justice, Joshua House, Michael Bendis, and Ben Field.
Okay. All right. Well, and does that pretty much complete, obviously, with Mr. Thacker representing the Attorney General's office? Is there anybody else we've missed?
Your Honor, Patrick McGee. I'm also here with the Finance and Administration Cabinet.
Right. Okay, Mr. McGee. Glad to see you on a case that does not involve the Model Procurement Code.
Yes, Your Honor. Thank you.
Okay. Well, so we do have a couple of matters then that we need to talk about, and I think maybe a good place to start is with Mr. Thacker in the Attorney General's office, because obviously the court, wants to be sure that I don't want to go very far down the road on any of these issues without giving the Attorney General's office the opportunity to participate, which I think they're entitled to under the statute and the rules. And I guess the first order of business may be to determine if the Attorney General is going to intervene and participate in the case. And so, Mr. Thacker, have you all reached a decision on that yet?
We have, Your Honor. Your Honor, I appreciate the language in your order last week, making sure that we got notice of this hearing, and we have vetted it, and we will be intervening. We can put on a motion for next week, or I don't know if that may be something we'll be able to do by agreed order, but yes, our intervention is forthcoming, whatever procedure is most convenient for the court.
Right. Okay. So, and again, I assume you all will be intervening, defending the statute, correct?
Yes, Your Honor. That is a correct assumption.
Yeah. Okay. All right. So, well, we will, maybe we can talk about the proper procedure. I don't know if does anyone anticipate an objection to the participation of the Attorney General?
Your Honor, we would not object to the Attorney General intervening. I think when we reach the point of talking about intervention, our concern is more the scope and keeping the attention to briefing. Sure.
Okay. And it seems pretty clear to me the Attorney General does have a right to intervene.
Exactly.
If wants to voice any objection, I want to give them the opportunity to do so. But if I don't hear any, I think I'm going to go ahead and just ask the Attorney General to, you do need to file a motion to intervene, I guess, and a tender an answer. But I will go ahead and in our order today indicate the court's going to grant that motion. And I don't know, how much time do you need, Mr. Thacker, to
Your Honor, we're obviously, we're still working on responsive pleading, but we'll have that filed sometime next week.
Okay.
No later than the end of the week, sooner if we can.
Okay. All right. Well, that's fair enough. I guess the other thing in that connection is obviously we do have motions to intervene now on behalf of a couple of parents and families who are seeking to defend the validity of the statute as well. And Ms. Snell, I think, has filed an indication that the plaintiffs don't object to their participation. As we move on, there may be some disagreement or matters we have to address in terms of what the scope of the the litigation is going to be. But again, I think the statute itself and certainly the traditional analysis under Rule 24 would I think would support intervention by the families, and I'm inclined to go ahead and grant that motion to intervene with the understanding that the plaintiffs may object to certain arguments that the interveners may advance. But so let me ask, and I'm not really sure if I should talk to Mr. House, but have you all tendered an intervening an answer?
Yes, Your Honor. We attached an answer to our intervention motion. So.
Okay. All right. Well, I'm going to go ahead and grant the motion to intervene on behalf of the families that you all represent, and we'll allow that answer then to be filed. And I guess the other question I had in connection with kind of the procedural posture of the case is with regard to the Finance Secretary Johnson and the Revenue Department. you all are named as defendants, but obviously your boss vetoed this legislation. So I guess I would like to have some understanding of what your position is going to be. Are you going to defend the law, or are you not going to defend the law?
Well, Your Honor, we do represent Secretary Johnson and Commissioner Miller. And I guess in response to that, I would say that we are still reviewing the complaint. And so, we do plan to file an answer in this matter. And so I think from a practical standpoint, the administration is interested in clarity from the court in terms of the constitutionality of this particular enactment. And so I think that's what we're.
When is your all's answer due, Mr. Thomas?
The 28th, Your Honor.
Okay. Okay. All right. Well, the other issue procedurally that I wanted to discuss a little bit is that I understand the plaintiffs have filed a motion for a temporary injunction, and I've been advised by my staff that they've inquired about a hearing date for that, and I think they were given a tentative date on July the 7th. But I wanted to discuss that a little bit because it does seem to me like, if it's possible, it would make sense to, if we could streamline the litigation so that we don't have to do a major round of briefing and argument and hearings on injunctive relief and then another round on the merits. If we could just figure out a way to get the case briefed and argued and submitted on the merits, that would make a certain amount of sense to me. But I'm also a little bit unclear about the mechanics of how this law operates. So that may have some effect on whether injunctive relief is necessary or appropriate, and I'm frankly a little bit unclear about, under this legislation, if it is anticipated that it's going to go into effect immediately for the school year that begins this fall, or if it's contemplated that it would not go into effect until the following school year. It appears to be tied to the tax year of 2021. But obviously tax returns are not filed for that tax year until next year. And I'm just not entirely clear about what the contemplated timetable is. And obviously, if the bill is, goes into effect on its normal effective date, there's still a lot of administrative work that will have to be done. I assume under the bill, it looks like there's a fair amount of administrative work to set up the mechanisms, the forms, and the approval of the entities who will receive funding and things of that nature. So I think maybe it would be helpful to get some guidance from Secretary Johnson and the Department of Revenue about what they anticipate in terms of the timetable here.
Thank you, Your Honor. And my co-counsel Bethany Rice is also on the call, and I may defer to her to some extent here, but it's my understanding that the Department of Revenue is currently preparing to administer this statute. And so I think part of the clarity here is that we are currently expending resources to get ready for the effective date, which I believe is June 29th. for this particular statute. We are expending resources currently, and so if this suit has kind of brought this whole process into question, and so again, we're seeking clarity here. But Ms. Rice may be able to tell you a little bit more about the details in terms of what the department has done in preparation.
What the mechanics of it. Okay. All right. Well, Ms. Rice, can you enlighten me on that?
Good morning, Your Honor. Yes, I can speak to that. Mr. Thomas is correct. The department is working on the implementation process, but there are several steps that they have to go through before the actual tax credits can be approved and awarded. So with regard to the beginning date of June 29th, there will still be, several administrative steps that will have to, the organizations have to be approved before they can accept those investments and the tax credits can be awarded.
Okay.
So the department at this point is working on forms and getting things like that in line and ready to go.
Yeah. Do you all anticipate doing an administrative regulation that would spell out the requirements or anything like that?
Yes, Your Honor. We believe a regulation would be in order for this because there are some gaps. And quite frankly, we're still working internally on interpreting those gaps and how best to implement it.
Mm-hmm. Okay. All right. Well, let me ask Ms. Snell on behalf of the plaintiffs, what's your view about the timing of any injunctive hearing? And I guess I'm just trying to understand whether we need to have a hearing in the next couple of weeks, or if we can go straight maybe to a briefing schedule on the merits of the case. So.
Yes, Your Honor. We obtained the July 7th date because of the effective date of the bill, which we understood, as Mr. Thomas said, was June 28, June 29. We assumed that finance was engaged in the sort of administrative process that they were engaged in. Obviously, a briefing schedule would be fine with us as long as, I guess, there's no, the implementation, if you will, of the bill until the validity of it is decided.
Mm-hmm.
And it sounds like if there could be an agreement or order or something that would maintain the status quo until the parties had an opportunity to brief it and in the efficient manner that the court is describing.
Yeah. Okay. Well, let me kind of open the floor to the interveners and the Attorney General and get their views on this issue of how we ought to proceed in terms of timing.
Your Honor,
Thank you, Your Honor.
I'm sorry, I'll defer to Mr. House. He started talking.
Okay.
Thank you. Your Honor, I think we have some concerns about what might in effect be sort of combining the TI motion with the merits briefing, if that means that there's not like a chance for actual discovery in the case. There are fact issues that have been put into issues by the plaintiff, such as whether certain schools discriminate, whether there's a public purpose. And there's also the basic facts for our clients about whether they are actually beneficiaries, in what way it benefits them, how the program actually works, and the mechanics, as Your Honor already mentioned, about where the money's coming from. Is it being diverted or is it not? So I think these fact issues, if, our position is that they haven't stated a claim legally, but to the extent they have, I think that these fact issues need to be proven up. And I would be just concerned about waiving a discovery period in the name of expediency. And of course, our clients do not want this program to be put on hold any, later than this upcoming school year. So.
Yeah, so do you all anticipate, Mr. House, that that the statute would be implemented and funds would be available this fall?
I don't know about sort of the administrative internal affairs, but I do know that it should be available based on the effective date of the statute. As soon as there are AGOs that can accept donations that are registered with the department, I think they can start distributing the accounts to parents that qualify. And that could very well, and in fact, our clients would much like to see that happen before the beginning of this school year.
Yeah. Okay.
Judge, we do not see the need for any discovery or evidence. As we've explained in the response to the motion to intervene, the bill says what it says. The Constitution is clear, and it's purely an issue of law. Given what Mr. House has said, then I believe there is some urgency, and perhaps we would like to hold on to the July 7 date or something shortly thereafter.
Well, of course, there may be a disagreement about whether there are disputed issues of material fact, and that's something I will have to sort through after you. But I would anticipate maybe a dispositive motion then should be filed, relatively soon. And then if there are facts, obviously, that are in dispute, I'm going to give people the opportunity to take discovery. But I guess what I hear Ms. Snell saying is that they're challenging the statute on its face, and the factual issues that have been raised by the interveners really are not material or relevant to the adjudication of the facial challenge. And I don't know the answer to that right now, but I think that will be relatively, straightforward for the court to figure out when we get the proper motions before the court. So, Mr. Thacker, did you have any observations for the court about this?
Yeah, and Your Honor, we have not, frankly, we're not far enough along our analysis to have really a position on whether discovery is necessary or not. I will note that the key factor will be where's the money coming from, but I think that is either something that could be narrowed down on the terms of the statute itself or stipulated, but it may be later. We see other issues, but I'm inclined to agree that relatively soon we should be able at least to brief and determine the facial challenge. One concern I have is we are interested in delaying this, particularly if there are, and it sounds to me like there are substantial regulatory and process steps that the state's going to need to complete before anyone submits an application for one of these. And I don't want that to be put on hold. If we can have that continue while we, over the course of next month, going to brief at least the facial constitutional issue. Yeah.
I mean, I do think that makes sense. And I would also say, it seems to me like really the only, it seems clear that the Department of Revenue has a number of significant administrative steps that they're going to have to take in order to approve the AGOs. I think where it becomes a question is going to be that when donors start making donations and are expecting a tax credit in return, I don't want if there's a substantial question about the validity of the act. I think we need to resolve that before people start relying on that and making donations and planning their tax affairs. And again, I don't know what the timetable, but I assume it will be a little while before the Department of Revenue is ready to start approving AGOs. But until they do that, there's a little bit of flexibility, it seems to me like. you know, we may, Miss Rice, do you have any kind of timetable that the department has in addressing those things?
Your Honor, I can't speak exactly with that. We are meeting. We've had several meetings about it, but they do anticipate it will take some time to
Yeah.
approve. And we aren't really, we being that it's a new statute, a new statutory framework, we're
Yeah.
not even sure of what sort of AGOs might be out there that are qualified at this point.
You're in, I understand you're kind of in uncharted territory. That's, you know,
Yes, Your Honor.
never been done before. So, okay. Well, taking all that into consideration, again, I'm not still very sure of what the timetable is and what the equities are, but it seems to me like in that case, maybe we ought to go ahead and conduct a hearing on July the 7th on the motion for a temporary injunction. I would say that that also gives us some time between now and July the 7th for council to, to meet and confer and to see if you all could reach some kind of an agreement with regard to, whether with regard to briefing schedules on the merits and dispositive motions. And I understand it's clear there's already going to be some dispute about whether there ought to be discovery. And again, I think that it's going to be dependent on the court's ruling on the initial motions, which, I think could happen and I hope will happen on a fairly expedited basis. So maybe you all could reach an agreement with regard to briefing and submission of an initial dispositive motion. It sounds like the plaintiffs contemplate making a dispositive motion at a very early stage. And if we could get that briefed and submitted, then we can move forward. And whether that it's necessary or appropriate to enter injunctive relief while the briefing of the the initial dispositive motion is taking place is something the court will reserve on until we have a hearing and everybody gets a chance to make their legal and factual arguments at a hearing, and then we'll just move forward on that basis. So,
Your Honor.
Yes, Mr. Thacker.
To the extent that we may need or want to file a response to the motion for temporary relief that's to be heard on the 7th, when would the court need responses?
Yeah, let me think about that, because let's see, looks like the 7th is a Wednesday.
And I believe that Monday is the 4th observed.
Yeah, so that'll be the holiday. Yeah, so I guess I would like to have any response to the motions for temporary injunction filed by Friday, July the 2nd. And then if Ms. Snell, if the plaintiffs want to file a reply, they should do it on July the 6th.
Thank you, Judge.
And we'll go ahead and keep that July the 7th date at 2 o'clock for a hearing on a temporary injunction. So, okay, any other questions or concerns that we should address here just to address these initial scheduling matters and procedural issues?
Your
Your
Honor,
Honor, just go ahead, Mr. Thomas.
thank you. In speaking with the clerks, there was some confusion. There were possible hearing dates on June 28th that were scheduled, so I assume that those have been remanded from the docket.
Yeah, I don't think we need to. I think July the 7th is as soon as we can do it and give everybody a fair opportunity to to file their papers. So, and I don't see any urgent need to do it on the date of the effective date of the bill, since it's clear that the Department of Revenue is not going to be able to take any definitive action in terms of approving AGOs or the procedure for obtaining an AGO certification. And until that happens, it seems to me like that, that's the thing that could, I think, potentially trigger, an immediate issue in terms of how the bill should be dealt with during the pendency of the litigation. So I think we can sort through that better on July the 7th. So, okay, anybody else?
Your Honor.
Mr. Walther?
Yeah, thank you, Judge. Are you wanting a Zoom hearing on the 7th or an in-person hearing?
That's a good question. We've got a lot of people coming from, it looks like a lot of different locales here, and we've had pretty good luck in conducting hearings by Zoom. So I'm kind of inclined to do these initial hearings and the injunctive relief hearing by Zoom. So why don't we plan on doing it? We'll plan on doing it through a Zoom call. And if there's any problems or concerns, you all can let me know about that in advance. But it seems to me like that might be the most efficient way for us to conduct the hearing.
And Your Honor, I had one final procedural question.
Anybody else?
Just in terms of procedure. So again, we will file our motion to intervene and attach the responsive pleading to be tendered. Do we need to notice that for any motion hour, or just or notice for the 2nd in case the 7th?
I think you can just go ahead and submit that. And again, if I will say, if anybody has an objection to your intervention, they need to speak now or forever hold their peace. We're going to have plenty of things that people disagree on in this case, but I don't think that's going to be one of them. So I'm just going to go ahead and indicate in the order that the court will grant that motion, and you have until next Friday to tender the appropriate pleading. Okay.
Thank you.
Your Honor, Brian Thomas, obviously we have not seen their motion, but it is the, position of the administration that, our legal department will be representing both finance and administration and the commissioner's office, but we have no objection to the AG intervening.
No, I understand. You all are going to maybe have some different roles, but again, I think the statute's clear on the right of the Attorney General to intervene, although certainly I will expect Secretary Johnson and the Department of Revenue have their own counsel, and you all may not agree on everything. So, but I don't think there's going to be a problem in any representation of potentially divergent interests by the Attorney General's office and the Finance and Cabinet and Revenue Department. So, okay, anything else? All right, well, I will get an order out that will kind of summarize our discussion here and confirm the matters that we talked about in terms of the hearing. And then I will say once we, and I would also say on July the 7th, when we hear the request for injunctive relief, by that time, I would expect, the potential issues will be somewhat clarified, and I will also expect to have a discussion on July the 7th about how to brief and submit dispositive motions or cross motions, depending on what you all want to do, and address these threshold legal issues, which may or may not be dispositive of the case. But I want on July the 7th to be prepared to have that discussion, and I would encourage council between now and July the 7th to go ahead and initiate discussions among yourselves about whether you all can reach an agreement with regard to how we proceed on those issues. Okay. All right. Well, I think that covers our agenda for today, and I will get an order out. And is there anyone else that had an issue or concern you want to raise? Okay. If not, I want to thank you all for your participation, and the court will stand in recess.